Okay, real quick review from last week's module. We had outlined the purpose of constitutional law. We said that its creation was really a product of the Revolutionary War when the U.S. won its independence from Britain. We know that in doing so, they had to establish a government, and because they were so concerned about the power of the British government, they wanted to ensure that the U.S. government was set up in a way so that no government actor could take on too much power. So they created the three branches of government to create that separation of power. And they also came up with several specific laws that provided basically freedom or protection from government action for the U.S. citizens. So we know the purpose or the background behind the U.S. Constitution. We also know the relevance of state action, right? That basically in order to be sued under constitutional law, you have to be considered or classified as a state actor, right? So basically any organization or individual that is acting on behalf of a governmental body is subject to regulation under the Constitution. Again, keep in mind we looked at several examples of how K&R organizations might fit this definition of state actor, right? So we have public parks and recreation organizations and officials would meet this definition. Public school officials and teachers and administrators would meet this definition. And so on and so forth. So make sure that we're keeping this state actor lens on as we review the concepts for this week, knowing that private K&R organizations don't have to comply with the same policies or rules under the Constitution. But as we said last week, that doesn't mean that they can't be held accountable or liable under the law. It just may not be constitutional law. So again, just keep that state actor lens in mind as we look at the new concepts for this week. This week we're going to cover two specific amendments within the Constitution, the first of which is the First Amendment. So we're going to look at some of the specific freedoms outlined in the First Amendment. And then we're also going to discuss issues of discrimination that are dealt with in the 14th Amendment. So that will be part 2 of the video lecture. Part 1, we're going to focus here on the First Amendment. Okay, I want you to take a few minutes here and just think off the top of your head, can you name the rights that are inherent in the First Amendment? So what are your First Amendment rights as a U.S. citizen? So again, just think about from your own memory, maybe you've already read the textbook reading for this week, maybe just jot down what those inherent rights are. Okay, you've had a few minutes to think. Let's reveal what those rights are. We know from the First Amendment that there are essentially 5 specific freedoms outlined, right? We have freedom of religion, freedom of speech, freedom of the press, freedom of assembly, and freedom to petition the government. So as you can see there, if you weren't able to name all 5, you are not alone. 33% of the American public could not name any of our First Amendment rights. So you're already ahead of them now. Okay, so what I want to do with the rest of our time here in part 1 of the lecture is just to go into depth on each of these First Amendment rights. We're going to spend the bulk of our time talking about freedom of religion and freedom of speech. We'll also talk briefly about assembly and press, but really the focus of our conversation will be on those first 2 rights because in terms of application, those are the 2 that are probably most likely to impact you as a K&R practitioner. Okay, let's start by looking at freedom of speech. So we know that because of the First Amendment, it is illegal for a government actor to abridge the freedom of speech. So essentially, all American citizens have the right to communicate their opinions or ideas without fear of government interference. Right? So basically, we have the right to say what we think without having to worry about the government stepping in and stopping us. Even if others don't agree with what we're saying. Now, this is obvious to us, right? We've all grown up with this particular right, but this isn't necessarily something that all other countries enjoy. So it is pretty prominent in terms of what we have or what we enjoy as U.S. citizens. Now, when we refer to freedom of speech in the First Amendment, we're also referring to expression, right? So it's not just spoken word that is protected under freedom of speech, but also how we choose to express ourselves beyond that spoken word. So, if you think about some of the ways you might express yourself without speaking, might be the clothes that you wear, the way that you wear your hair, if you choose to get a tattoo, if you choose to hold a sign in protest, all of those would be examples of expression. So keep in mind that when we talk about freedom of speech, we're not just talking about spoken word, but we're also talking about all those forms of expression that are covered or protected here. Okay, so there are some limits on freedom of speech, and I think it's important that we outline those, and you'll probably recognize some of these concepts from our earlier conversations. So some of the limits here. If speech actually incites violence or it violates a criminal law, then it is okay for a state actor to step in. So if you're hosting a recreation event in a facility and someone stands up and screams, "There's a fire," right? And that incites everyone to run out of the building. There's actually no fire, right? So they're doing so just to incite violence or fear within that group. You could step in as a state actor and stop them from doing that, or punish them, or ask them to leave. So inciting violence or any speech that violates criminal law is not protected. Defamatory speech is not protected under freedom of speech. So back to our unit on intentional torts when we talked about defamation, so making a false statement against someone that harms their reputation, that kind of speech is not necessarily protected under the First Amendment, obviously because it is breaking another law, right? One other limit here that your textbook discusses is using a person's likeness without their permission. Again, you'll remember back to some of our conversations earlier in the semester, this relates to that concept of appropriation, right? So using someone's likeness without their permission and then earning money off of that likeness is appropriation. And so that the courts have considered to not be protected speech under the First Amendment. Some of you who are into video games might remember EA Sports, a company that used to put out specific games for NCAA sports. So there was NCAA football and basketball. These were very popular games for a time, but then some of the former athletes decided, they were never asked their permission to use their image or likeness in these games and were not being given any kind of compensation for it. So in those legal cases that went forward, the courts basically said that it is not a protection under freedom of speech to use the likeness of these athletes for this creative purpose in the video games, and therefore they actually had to stop making the games. So that's an example of another limitation on freedom of speech. So you might be thinking, what about the regulation of speech by private entities? We know that state actors cannot limit or regulate speech by individuals, but you might be thinking, how does this work for private entities and the policies they have surrounding speech? Well, again, we know based on the state actor concept that only those that meet our definition of state actors have to comply with this particular area of law, constitutional law. So these headlines here by private organizations in our field, so the NFL, the NBA, US Soccer, these are not state actors, right? So they have a lot more flexibility in terms of how they treat issues of regulating speech. So some of you might remember a few years back, Colin Kaepernick decided to start kneeling at football games when he was a quarterback. He was kneeling to protest police brutality in the United States during the national anthem. If you follow football at all, you know that this ultimately led to the end of his career in the NFL and loss of his job, essentially. And in the wake of that, several of these private sports leagues enacted policies to keep players from making a similar stance, right? From taking a similar form of expression, which was kneeling during the national anthem. So you can see that if these were public organizations or if these were state actors, that there would be some issues here, right, under constitutional law, that they would not be able to limit these players from taking some form of expression. And in these cases, they're able to do so because they're private entities, right? So those same statutes under the First Amendment don't apply to them. So if the NFL wants to, they can fine players if they kneel during the anthem. If the NBA says we have a policy that says all players have to stand during the anthem, that's okay because they're a private entity and they have a lot more leeway in terms of the policies and regulations they set. So again, just to showcase that as we're thinking about these constitutional law issues and who has to comply with them, state actors are going to have a lot less freedom or leeway to impact or regulate the speech of their employees or members, where private entities have a lot more leeway because they're not subject to those same policies. Okay, so in order to determine whether or not a state actor is guilty of constricting speech, the court has to basically balance a couple of key issues here. So remember back to our conversation last week, we said that in any constitutional law case, courts are basically balancing two things, right? The right of the individual and then the government interest, right? So what is the government interest or reasoning for having a particular policy in place? And then there's that individual's rights under the Constitution. So again, we have this scale where we're trying to determine as a court which outweighs the other, the government interest or the individual's rights. So in terms of testing for freedom of speech or whether or not a state actor has constricted that speech, the court is going to look at these two main issues, right? So does the state actor's interest outweigh the plaintiff's right to express themselves? So is their reason or their policy for limiting speech, is that enough to outweigh the plaintiff's individual right of expression? Okay, so that's the first question. The second question, is the speech or expression a matter of public or private concern? So just a little bit of context here in terms of what that means. Public speech exists basically when someone's talking about matters that are considered to be political, social, or have concerns outside of that individual's life, right? So these are issues that are impacting other people on more of a global social level. So anything that would be commenting on a war or commenting on a new law that's passed, or really any kind of social commentary would fall under this category of public concern. Whereas private concern or speech that is a matter of private concern really just deals with that individual and their personal preference for speech or expression. So let's say, for example, that a student athlete has decided they want to wear hoop earrings while playing volleyball, right? That would be a matter of private expression, right? They are choosing to express themselves by wearing these earrings. That expression does not really bring in any kind of bigger political, social issues, right? So they're just their personal preference. Where a student athlete who decides they want to wear a t-shirt that makes a statement or a political statement about what's going on in the country, that would be a matter of public concern. Generally speaking, courts are more likely to protect speech that is a matter of public concern, right? As opposed to private concern. And we can look at an example case from your book to show this. This Tinker versus Des Moines School District case from the late 60s is really a precedent-setting case in this area. Here you had two students that were protesting the war in Vietnam at the time, and they started wearing these black armbands to school to protest the war. The school initially told them, you cannot wear these. This is a distraction from other students and their learning in the school. And this case did go to court, and essentially the court decided that the students' individual rights to express this public concern over the war in Vietnam outweighed the school's reasoning for limiting that speech, right? So they said they were limiting the speech because it was a distraction, but ultimately the courts decided, hey, this is about a really important issue, a public concern, and therefore we don't think it's okay to hamper or infringe on that speech. So that Tinker case is really a precedent-setting case in establishing the rights of students within our school systems. Okay, so ultimately, when we think about expression, particularly in a school setting, we think about the different public protests that could take place. This is essentially what's been determined acceptable. So as long as students are meeting these particular requirements when they are protesting or expressing themselves, then that speech is protected. So assuming that the protests themselves are peaceful, they do not create a substantial disruption to the school, and they do not violate the rights of other students, then in general, that particular speech cannot be infringed upon by that school. We've seen over the last few years several walkouts in schools across the country, whether it's for gun violence or the environment. We've seen plenty of these situations where students are walking out in peaceful protest, and the schools don't necessarily step in because they know that under the First Amendment, these students have a right to peaceful protest, to express themselves and their concerns, particularly if they are for a public concern, right? And in these cases, these issues are. So as long as they don't create a substantial disruption to the school as a whole, and as long as they don't violate the rights of the other students, and they are generally peaceful, they are allowed to go on. Okay, so do want to talk briefly about another type of speech that is protected under the Constitution, and that is commercial speech. So when we say commercial speech, essentially we're talking about any speech that's used to promote a product or service. So think about companies that advertise their products to the public, right? That's the type of speech we're talking about here, whether it's through a television commercial, a print ad, maybe a social media viral video. Any kind of speech that is used to promote a product or service would fall under this definition of commercial speech. So it's important to know that when we talk about commercial speech in the context of the Constitution, while there are protections for these companies, meaning that the government in general cannot step in and limit commercial speech, there is less protection than for matters of public concern, like we talked about on the last slide. And in particular, if commercial speech misleads the public, meaning that the advertisers say things or characterize things in a way that will mislead the public into thinking something that isn't true, then it is okay for the government or a state actor to step in and limit that speech. So let me show you an example here of where this occurred. So you had Skechers develop this product called Shape Ups. You might remember them from a few years back. And they created this entire ad campaign around these shoes. I'll let you take a look at one of the ads here now, and then we'll come back around the other side and talk about why the government stepped in.
Get in shape without setting foot in a gym with Shape-Ups from Skechers.
I already feel a difference in the way my jeans fit. My feet, legs, and back don't hurt at all anymore.
I'm Joe Montana, and I spent 16 years playing football, and Shape-Ups have improved my strength and posture.
Get in shape. Shape-Ups from Skechers.
Okay, so as you can probably tell by watching that advertisement, there's some misleading statements being made, right? This idea that by putting on a new pair of shoes, you're actually going to tone your body and physically change its shape is very misleading, right? We know that based on, basic science that this is not going to happen, right? You actually need to exercise, eat well, and do a lot of other things in order to see those kinds of results. So this was a case where the government did step in, basically blocked this particular ad campaign from ever being aired again because it misled consumers. So again, commercial speech is generally protected under the First Amendment, meaning that companies who are marketing or promoting their products and services are able to say pretty much what they want, unless it misleads the public. So again, just important to note, especially as some of you think about working on the marketing side of things for a recreation or sport organization, that you do enjoy a level of protection under commercial speech, as long as you're not making statements that would mislead the public. Okay, so another freedom that's inherent under the First Amendment is this freedom to assemble, right? We know that basically we all have the right to gather with others and other groups of individuals and for any kind of cause that we'd like, right? So we know in our field there are a ton of examples or instances of freedom to assemble being expressed, right? Anytime we gather together with other sports fans to watch a sporting event, we're exercising our freedom to assemble. Anytime we gather at a music festival or concert, we're exercising our freedom to assemble. Anytime you get together with a group of friends and go on a nature hike or some kind of other outdoor recreation activity, you're exercising your freedom to assemble. Obviously, from a practitioner perspective, we're also facilitating plenty of groups assembling at different times. So this one is particularly important for us to be aware of. Now, generally speaking, we have this ability to assemble so long as there isn't any clear and present danger or any kind of imminent incitement of lawlessness. So the government or state actors cannot step in unless they sense some kind of clear and present danger or some kind of lawlessness is taking place. So you can think about a sports team parade after they win a championship, right? I know that when the Blackhawks won their most recent Stanley Cup, there were these riots in the street, right, in Chicago. And for the most part, they're peaceful gatherings of people celebrating the Stanley Cup. But there were some instances where people were getting rowdy and they were drunk. And in those cases, it was okay for the police or the state actors to step in. So keep in mind that generally it's okay to allow folks to assemble, assuming they're doing so in a peaceful and non-violent way. I do think it's important to note that when we think about assembly and this right, that the courts do not care about the content or the reason for the gathering, right? That's not relevant to whether or not it's legal for those groups to gather. All they're concerned about is whether or not the groups are doing so peacefully. So I'm going to share an article on ReggieNet about a recent issue or legal issue relating to the First Amendment and the freedom to assemble. And that deals with the case of the Unite the Right rally that took place in Charlottesville a few years ago. So the group wanted to rent this park space, and ultimately there were some disputes about the content of their rally and their reasoning for gathering. But as you'll find in the piece, ultimately the judge allowed the rally to stay in the park because, again, the content isn't the issue of the legal argument. It's whether or not the groups are peaceful and nonviolent. So I'll let you read a little bit more about that story later. Unfortunately, it has a fairly sad end, and ultimately some violence does occur. But take a few minutes to review that case as an example. Okay, so another important freedom that's inherent in the First Amendment is freedom of religion. So I want to take the verbiage of the law here because I think it's important in establishing what we're talking about. So Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. So basically we have two things happening here in terms of the freedom of religion component. On one side, we have what's known as the Establishment Clause, which basically states that a state actor or the government cannot promote a specific religion. Again, keep in mind that back prior to the Revolutionary War, American colonists were under British rule, right? And in that, they had a state-sponsored religion, Christianity. So when the founders were developing the U.S. government and constitution, they wanted to make sure that there was no state-sponsored religion, right? So that people had the freedom and ability to choose what they wanted to follow in terms of religion, or the ability to not follow any kind of religion. So the Establishment Clause made sure that that wouldn't happen, right? That the government could not promote a specific religion. The other piece of the freedom of religion statute is this free exercise clause. So basically that the government can't stand in the way of anyone who wants to or wishes to practice their religion. So again, two really ends of the spectrum here, right? On one end, state actors cannot promote a specific religion on behalf of the government, and then they also cannot infringe on individual citizens' ability to practice their own religion. You know that this case, Borden versus the School District of Township of East Brunswick, wow, that's a mouthful, was pretty precedent setting in terms of whether or not coaches or teachers could actually lead prayer within a sports team for a public school district. And you probably, if you've played sports before and you've gone to a public school, you've probably been involved in a situation where the coaches or the athletic director or the principal even comes into the locker room before a game and prays with the athletes. Well, technically, under the Establishment Clause, they cannot do that, right? That is exactly what the founders were trying to avoid, right? They did not want a state actor promoting a specific religion. So technically, under the First Amendment, state actors that represent those public schools should not be promoting any kind of specific religion. Now, with that said, the individual students themselves can and are able to practice any religion they wish, right? So the state actors in those cases cannot infringe upon the athlete's ability to do so. They just cannot promote a specific religion themselves. Another case here that was precedent setting in terms of the Establishment Clause is this Jaeger versus Douglas County School District. Again, the federal court in this case decided that it was unconstitutional for the school to provide a public prayer before the high school game. So again, they saw that as an infringement of the Establishment Clause, right, which stated that state actors cannot promote a specific religion. And by offering that prayer at the beginning of the high school game, they were doing so. I think it's important to think about the Establishment Clause and how it also applies to other officials, right? This isn't just the school districts that can't offer these prayers or promote a specific religion. It's the actual state actors themselves, right? So the coaches, the principals, the administrators, those folks are not able to promote a specific religion because they also meet our definition of state actors. Okay, so basically the courts have determined what we call the Lemon test to test whether or not there's been an infringement of the Establishment Clause. So we'll go through the steps here of the Lemon test and then we'll look at an example and try to apply it. So in order to pass the Lemon test or allow any kind of religion in a school setting, you have to pass these three elements. So the first one, the practice has to be secular in purpose, meaning that it has to be broad or general enough, non-religious, more spiritual, if you will, than promoting a specific religion. So under the Establishment Clause and the Lemon test, any kind of religious practice cannot identify a specific religion or specific God. Part 2 of the Lemon test, the practice's primary effect can neither advance nor inhibit religion, right? So again, back to this idea of a coach talking about prayer prior to a game or even during a game or participating in that prayer with his or her athletes. That would be an advancement of a particular religion, right? And then finally, the practice has to avoid excessive entanglement with religion. Right? So let's look at this example case, and then we'll come back to these this three-part test. So suppose that you are an athletic director of a large public high school. The football coach, who's heavily involved in his own church, would like to invite a minister from his Catholic church to speak and pray with the team in the locker room prior to the game and tell them about how they can get involved with the church in their free time. What is your decision? Well, again, if we're really faced with this issue, we probably want to go back to that Lemon test and see if it would pass. So first question, the practice must be secular in purpose. Based on what we know here, would this be secular in purpose? I think it's pretty clearly no, right? We're talking about a very specific religion here, so the Catholic Church. So it certainly wouldn't meet the requirement of being secular, right? If the coach wanted to bring in someone just to speak generally about spirituality, that would be different, right? But instead, they've picked a very specific area of religion to focus on. Okay, the practice's primary effect can neither advance nor inhibit religion. What do we think? Would this pass part 2 of the test? Again, probably not, right? We've got this minister who wants to come in and talk about how the student athletes can get involved in the church in their free time. So it's pretty clear that they want to advance a specific religious cause here. And then finally, the practice must avoid excessive entanglement with religion. Again, I think pretty clearly here this would not pass part 3 of the Lemon test, right? Clearly, this relationship between the coach and this minister is showcasing an entanglement with religion, right? And if they bring this person into the locker room, now they have very clearly entangled the student athletes with this religion as well. So again, if we think about what your decision would be as an athletic director, this would obviously put you in a tough position because now you have to tell the coach, hey, this isn't okay. But very clearly under this Lemon test, I think you could explain that this would be illegal and that the school district could put itself in a position to be sued under the Establishment Clause. Okay, an important question going back to the second part of the Freedom of Religion clause is, does it matter if the prayer is student initiated? So remember, we said that this free exercise clause protects individuals who wish to practice their own religion. So generally speaking, under the Constitution and prior court decisions, as long as any kind of prayer or religious discussion within these settings is student initiated or student led, then the courts generally have supported that practice. So as long as you take the administrators and the schools out of it and everything is student initiated, then generally speaking, that kind of religious entanglement has been okay. And I will upload another current case or fairly current case here in Texas where a group of Texas cheerleaders had held up signs displaying Bible verses at the football games. The school had made them take the signs down after hearing some complaints from local community members. This case went on for several years, and ultimately the appeals court did side with the Texas cheerleaders. Again, going back to that free exercise clause where they essentially said, as long as the school itself, the state actor, is not involved in this process, then those student athletes are just exercising their right under the First Amendment. So it's a complicated issue and one that does garnish or bring up a lot of discussion and controversy in some cases, but it's important for you to be aware of those two clauses and how they might impact your role as a K&R practitioner. One other issue here that I wanted to mention in terms of freedom of religion, and a common question that comes up for us in our field is it okay for park districts to rent out public spaces to religious groups? Or in doing so, do we see that entanglement? And the truth is that every state is different when it comes to enforcing this particular area of law, but generally it's seen as okay for park districts to rent out public spaces. Let's say a church wants to rent out a park for a one-time service, right? They want to have a day where they're holding their service outside as opposed to in the church. So generally speaking, courts have ruled that this is okay as long as the specific religious groups don't have an exclusive relationship with that property. So meaning, let's say the park district doesn't have an exclusive relationship with that church or religious group to use that space. And also as long as the park district does not favor one religion over another. So they're not prioritizing space to one particular religious group over another. So as long as those two requirements are met, then it is okay for park districts to rent out space to religious groups. Okay, one other of the freedoms that I want to mention briefly is freedom of the press. And again, this isn't necessarily something you'll probably have to deal with a whole lot in our field unless you get into the communication side of things, or you're working for an organization that deals with the media or the press often. But I still think it's important for you to be aware of just as citizens of this country. So the freedom of the press component of the First Amendment guarantees that the news media can publish any material they want without fear or punishment by the government. So basically, the founders wanted to make sure that the news media was free to report on what was happening in the country without having to worry about being thrown in jail for maybe criticizing or being critical of the government. And again, this is not a freedom that is enjoyed by all countries across the world. So we're very lucky to have this freedom where it's prioritized that the public get information above all else, and not that we protect government actors. So, this particular area is one that's definitely a topic of note today, where we have, a current presidential administration that in some cases does threaten the press or members of the press, and in some cases has actually removed press conferences, daily press briefings from what's been very normal for previous administrations. So again, this particular area of the Constitution is always topical, and we want to ensure that the news media has the ability to access information and get that information to the public. It's crucial to our democracy that this freedom stays and continues to be protected. But ultimately, in our field, again, you might see freedom of the press issues if you're dealing with members of the media. So an example that I give is the IHSA. This was a case that occurred a couple of years ago now, 2007, where the IHSA essentially started denying on-field press credentials to photographers. So they would host the high school football championship events, and basically they had a contract with a photography company that would get, those big photos right after the end of the game where the team was celebrating the victory. And because they wanted to make sure their paid photographers got the best photos, they were denying on-field press credentials to other members of the news media. And members of the news media here locally, of course, as you can imagine, got upset by this and said that it was an infringement of their freedom of the press rights. So this is a real life example here locally of a KNR organization being involved in a First Amendment case. And I'm going to post the full article of this to ReggieNet, so if you want to read a little bit more about how that case played out, you can. Okay, so I'm going to pause here and upload this video, part 1 of our video lecture, and then part 2 of the video lecture will pick up with the second part of our unit, which is equal protection and discrimination under that 14th Amendment.